my name is Divya Hazra. I'm a legal advisor at the India desk of Diandra and Partners Legal Counsel. In my today's video, I will be talking about how to set up your business in India. Now, without further ado, I would like to share my presentation. Well, to first briefly introduce you to my law firm, Diandra and Partners Legal Counsel is a full-service law firm. We provide services in relation to environmental law compliances, labor law compliances, FDI, ODI, IPR, dispute resolution, corporate M&A, etc. We have 9 offices globally, as you can see in my presentation. We are based in 5 different countries of the world, including UAE, Vietnam, China, Italy, and India. Now, to take you through the outline of my presentation, I'm going to be touching upon 3 topics today. One, I will introduce you to several concepts in relation to starting your business in India. Second, I would be taking you through certain key considerations for the investment that you're going to make. And third, I'm going to be dealing with the regulatory compliances and procedures around starting your business in India. Well, what are the advantages of making or setting up a business in India? First, active demand. The population of India of 1.3 billion has active demand, and the population is rapidly increasing, which means there could be a huge market for your products. Second, the labor cost that you will incur in relation to setting up operations in India is very, very less. Second, the policy support. Well, there are several subsidies which have been introduced by the government and tax reforms which are investor friendly and which are oriented towards getting more and more foreign investment into India. Fourth, the economical operational costs. Well, the infrastructure that is generally key to setting up any business, the costs in relation to such infrastructure in India would be relatively cheaper than other countries of the world. Well, the FDI policy of India. When you're starting your business in India, the first thing that you have to check is whether your investment is compliant with the foreign direct investment policy of India. Now, the FDI policy of India is amended almost on a yearly basis. And there are 2 key bodies which deal with FDI in India, which is the Reserve Bank of India and the DIPP, which is a department of the government of India. Now, the FDI in India is divided into 2 sectors, the permitted sector and the prohibited sector. Well, I'll first take you through the prohibited sector, which is relatively short. There are 8 sectors in which FDI is prohibited, a few of which are lottery or gambling, real estate business, and those sectors which are not open to private sector investment. Second sector that is in which FDI is permitted, there are divided into 3 categories. Category 1 is that under which 100% FDI is permitted under the automatic route. Category 2, where 100% FDI is permitted under the government route. And then we have category 3, where FDI is permitted under the automatic route and government route, which means after hitting a certain threshold, you might require the permission of the government of India. Now, once you have checked the FDI compliance, the next big step that you need to make is deciding on the structure of company that you need to set up in India. Now, that would be dependent upon your size of operations in India. What are your long-term plans or your short-term plans of investment? What is the size in which you want to set up your operations in India? Now, considering these factors, you may decide to choose more of a permanent base in India, where you can set up an Indian company, which can be again in 2 forms, as you see in my presentation. One in the form of a joint venture, second in the form of a wholly owned subsidiary. I will be taking you through more details in my slides to come. Second form is setting up a foreign company. Now, this can be done in 3 ways. In the form of a liaison office, in the form of a branch office, and third, in the form of a project office. Now, like I mentioned in my previous slide, there are 3 kinds of foreign companies that you can set up in India. One being a liaison office, which is where you represent your parent company and you cannot undertake any commercial activity. Second is setting up a branch office where you can undertake research, export and import of goods and provide consultancy services. The third is setting up a project office. That is for those foreign companies which wish to undertake a one-time investment in India. Now, this is more of I would say, less permanent presence in India. But if you're looking for more of a permanent presence in India and you want to have full operations, full-fledged operations in India, then there are 4 different kinds of companies that you can set up in India. First, as you can see in my presentation, it's a private company. Second is a public company. Third is a one-person company. And fourth is a limited liability partnership. Now, the first 3 kinds of companies that you see in my presentation, they are governed by the provisions of the Companies Act 2013, whereas the limited liability partnership is governed by different legislation, which is called the LLP Act of 2008. Now, what is the difference between these 4 kinds of company? Now, a private company, as you see by the name, is a company where public shareholders are not permitted. A public company, just like the name says, is where a public shareholder is permitted. A one-person company is a new concept which was introduced in India, where essentially you can set up a company by just one shareholder. The fourth is a limited liability partnership. Now, what is a limited liability partnership? It's kind of like a hybrid between a partnership and a company. Well, in a partnership, one partner could be held liable for any error committed on the part of the other partners. But in a limited liability partnership, the liability of a partner is limited to his extent of shareholding in the partnership. Now, some of the key differences I have laid down here for your consideration. Now, in a private company, a minimum of 2 and a maximum of 200 members are required. In a public company, there's 7, and you can have unlimited number of members. In a one-person company, you require just 1 member. In limited liability partnership, you require a minimum of 2 partners, and there is no limit on the number of partners that you may have. The minimum number of directors which is required to set up each of these companies. For a private company, it's 2. For a public company, it's 3. For a one-person company, it's 1. And for a limited liability partnership, you would not have a director, you would have a designated partner. Now, the maximum number of directors that you can have in each of these companies, as you can see in my presentation, for a private company, public company, and one-person company, it's 15. But this number can be increased by passing a special resolution. Now, one key consideration that you need to keep in mind when appointing directors for your company here in India, one of the directors of your company have to be resident directors, which means they have to have resided in India for a period of 182 days in the previous financial year. When it comes to the number of the shareholders could be foreign companies or foreign individuals. There is no requirement of any Indian citizenship or Indian residence when it comes to shareholding. But when it comes to directors, like I mentioned, the director should have resided in India. Now, some other key differences, like I told you, public ownership of shares. In a public company, you can have public subscription, but in the other 3 forms, you cannot have public subscription of shares. And the other key difference is in a one-person company, the shares can be transferred only when the nominee of the owner, only when the owner dies, can the nominee of that owner take over the ownership of the company. And in the other 3 forms of companies, that is a private company, public company, and a limited liability partnership company, ownership can be transferred at any point in time. Now, what is the timeline, the number of days that it would take to set up each of these companies? For a private company, it would take 1 month. For a public company, it would take 1 to 2 months, as the process is a bit more complicated because public shareholders are involved. For a one-person company, it would take 15 to 20 days. And for a limited liability partnership, it would take about 25 days.
Now, in my last slide, I would be taking you through the most common structure which foreigners or foreign companies choose to set up operations in India. That is by setting up a private limited company in India. Now, why so? Because the procedure is fairly simple to set up a private company in India, and the costs and the timeline involved in setting up a private company in India is relatively much, much less compared to the other structures of the companies that I explained to you before. Now, once you've done the FDI check, you decide to make an investment in India and you want to set up a private limited company in India, what are the steps that you will have to undertake? First, you will have to check for the availability of the name and you will have to register the name of your company on the website of the Ministry of Corporate Affairs in India. Once you have done so, you would move on to your directors and you would obtain something called a director identification number, which is a must for each of the directors of the company. You would have to obtain that from the Ministry of Corporate Affairs of India. After you've done so, then you submit the Form SPICE along with the memorandum and articles of association of the company. Now, what is the memorandum and what is the articles? The memorandum will state the key purpose or your key business purpose. The articles would lay down mechanisms in terms of your internal legislations of the company, like how would shareholders be allowed to transfer their shares, how can directors be removed, how can directors be appointed, how can directors pass a board resolutions. These internal legislations will be dealt with in the articles of association of the company. Now, once you submit these two key documents to the government of India, you are ready to have received a certificate of incorporation. Once you receive your certificate of incorporation, you can also obtain the tax registration numbers of your company, which is called a PAN and a TAN. Now, once you obtain your tax registrations and you have your certificate of incorporation, basis these documents, you can open a bank account. Now, once you've opened the bank account, you are 90% there towards setting up your business or starting your business in India. But once there is another key consideration which you have to keep in mind, which is the state registration process, which I've laid down as point number 6 in my slide. Now, why have I put that there? Because in India, there are certain issues where there are laws which are passed by the central government, but there are also laws passed by the state government. And depending on the state or the province in which you set up your office, you would have to comply with the rules and regulations passed by the state government of that particular state. To give you an example, now labor law in India, while the central government has passed certain central legislations, there are state legislations which also govern labor law issues. So you will have to obtain registrations under the laws of the state in which you set up operations.
With this, I come to the end of my presentation. If you found my video useful, do subscribe to our YouTube channel. And if you have any questions, do reach out to my email ID in the description below. Have a great day ahead and thank you so much for watching.